All right.
Listen to that, Your Honor. I've not been made aware of any motions being filed whatsoever. I'm completely in the dark about everything to do.
All right. Do you have a copy of the motion?
I can print up right now, Judge.
And if you'll give him a copy of the motion.
Thank you, Judge.
And again, I'll get to that motion right now ahead of time. If I cannot understand what this fingerprints are necessary to identify.
And Judge, the motion was duly filed to the court as well as to defense counsel, Mr. McCray, before the defendant decided to represent himself.
All right.
Mr. McCray is not giving me.
A defendant chooses to fight alone, but quickly learns a courtroom doesn't slow down for confusion. Motions collide, accusations rise, and the judge draws a hard line between fairness and legal reality. In this trial, preparation may decide everything.
From my case. Also, I would like to bring up that Mr. McCray has threatened my one and only witness with arresting her if she's come to court and testify for me. That's my only eyewitness that has proof that this robbery did not take place. And he told her that if she comes to court, that she stands the risk of being arrested.
All right. Have you all printed out the motion?
I'm pulling it right now, Judge.
Thank you.
Judge, we'd also make an oral motion in limine that the defense be barred from inquiring into any kind of criminal history of any of the witnesses. There are no convictions that I'm aware of.
One of the witnesses.
All right. So time out. One, we're going to let everyone speak one at a time. After people have concluded speaking, then everyone will have a chance to address whatever they wish to address. So you may continue.
Thank you, Judge. Judge, we would make an oral motion in limine that the defense be barred from mentioning or inquiring into any kind of criminal history of any of the witnesses. There are no convictions. So we would ask that there be no inquiry into any kind of criminal history or any kind of criminal acts alleged or not.
I would object to that, Your Honor, because two of the witnesses that are, first and foremost, they get to know my whole background. So these people are holding me, saying that I committed a crime. Their backgrounds need to be able to be ascertained as well. Furthermore, one of the witnesses that he's trying to protect is on probation currently for drug charges. Drug charges to prove that she is a drug addict, so which goes to the credibility of her statement. Furthermore, I also have a motion that I would like to.
No. We're staying with this motion. And then if there are other motions, the court will.
In regards to probation, it's deferred adjudication. She has not yet been found guilty of any offense.
All right. So with regards to the state's motion in limine, you'll need to approach before asking any question regarding any criminal history. And then at that time, I'll make a ruling. All right, next.
And Judge, those are all the state's pretrial motions.
I also have a motion I would like to turn in.
Now we're on the fingerprint and then we'll deal with your motion. So with regards to the motion that the defendant be fingerprinted, that will be granted.
Thank you, Judge.
All right. And what motions do you have?
This motion is actually a motion for continuance of 3 days, Your Honor, because I'm completely.
I have not seen the motion.
Okay. This is right here. May I make a copy of it and give it to the DA? Because I wrote this by hand.
You'll just need to show it to the prosecutor. No, you don't bring it to me.
The reason for this motion, Your Honor, is that I'm completely unprepared. I have not seen the motion. How do I let you see it? I wrote it here. This is it.
So this is what I'm going to explain to you. When you represent yourself, I am not allowed to tell you how to file motions. I'm not allowed to assist you because then I become your standby counsel, and I'm neither party's standby counsel. I'm just here to hear any evidence that's presented to me, any motions that are presented to me, and make rulings. That is all.
I would like to attention and report that I am under strict abilities that I can't participate like the district attorney does. I don't have access to a computer or a copy machine or any.
Oh, no, here's the thing. It is fine that, it's fine that motions are written, but they need to be given to the court in a specific way, and they need to be filed. Now, I am not here to tell you how to file motions. That is something that you need to know how to do, and you need to do.
You know how to do it, Your Honor. But if I was to file this motion, it would come past the time that this jury has been convened, and it would cause a problem with proceedings in court. So
That's not the way the law works. What you just said.
I don't know how else I'm supposed to file a motion. It's necessary at this moment when I don't have access to any of the basic things.
I just inform you that the court accepts written motions, but as far as my telling you how to do that, that is not what I'm here for. That is for you to decide how to do that in representing yourself.
So, Your Honor, I would like to make a verbal motion. The written copy of it is right here. May I?
And Judge, we would object under the Code of Criminal Procedure.
No, just a minute. It hasn't even been filed or brought before the court yet. And that is something that needs to be done. And so, Mr. Ross, this is what I'm going to tell you again, and I want you to hear me clearly. My role is not to help you with your case. I'm just here to listen to whatever is presented to me. That's it. If I seek to help you with your case, then I'm becoming your standby counsel. And then that means I'm not being objective. So I will not do that. And what I can tell both parties is I will only consider and rule on motions that are properly brought before the court.
I understand it. And I would ask for the court to have mercy and understanding. There are things that I'm limited to that I don't have access to at all. My hands are tied in this form of being able to.
This is what I'm going to tell you.
It's not fair.
No, this is what I'm going to tell you. And your attorneys will tell you this. My role in this case is not necessarily to have mercy and understanding. My role with regards to this jury trial is to listen to evidence, make legal rulings for motions that are presented before me, and make rulings on any objections that people may have. That is my role right here. I am not sitting. If you were found guilty, the jury would be in charge of your punishment. That's where mercy comes in. That is not with this court at this point in time. My only point is to review documents that are given to me.
My copies of the motion that I just did.
Right. If you'll make a copy, please. And a copy for the state.
On record.
Mhm.
Mr. McCray has been communicating with my only witness without my permission or knowledge. And
Let me ask you this, and this is the only time I will ask this question. So, is it your belief that attorneys are not allowed to talk to potential witnesses? No, that's my question.
it's not my understanding.
All right, so then I don't understand what you're asking of the court.
To understand an egregious crime that's taking place with obstructing justice from being served in form of interfering with my client. Well, my witness is a veiled threat that she would be arrested if she testified in my case. I need her. She is key to my defense. And he's giving her a veiled threat. And if she testifies for me, she stands a chance of being arrested.
All right, and is this something that you're saying that the witness has informed you?
Yes.
All right, that's what's called hearsay. All right, Anything else?
Recorded on conversation, Your Honor.
Anything else?
Yes, I would ask that the court please move to have this man removed from my case.
That's your standby counsel.
My standby counsel is moving arbitrarily to my best interest.
That is your standby counsel.
He has
And at
threatened
this
my
point
life.
in time, your standby counsels, Mr. McCray and Mr. Porter, are just that. They are standby. They are not doing any more investigation as it relates to your case.
He has.
They're just
As of
here.
last night, Your
Yeah.
Honor. He
All
said a
right,
meeting
next.
with my woman this evening after court.
Yes.
If I can make a record, Your Honor, I've spoken to Tawana Monday any number of times.
Wanya Monday.
Tawana Monday, I've spoken to her any number of times. I would like to think we have a solid enough relationship. I even got her to bring jail clothes to the jail for you. Okay, I've spoken to her numerous times, and yes, I'm meeting with her at 5:30 today on your behalf and to talk to her about her willingness to testify. Because yes, according to the state's allegations, it can make the argument that she was your getaway driver. So what I told her was, hey, you might want to consult a lawyer before you testify. I'm bringing her here today so that I will let her know if she needed one, she wouldn't even have to pay. This court would appoint her a lawyer to give her whatever advice and counsel that she needs. And if she got on the stand and pled the fifth, saying that she's not going to say anything because of any possible criminal liability on her part that does not reflect well on you, that's what I communicated to her.
I understand that, but before you even started communicating with her, she was full willing to be my witness.
All right,
You know?
so stop. This is what I'm going to tell you. Number one, any witnesses that may or may not place themselves in a potential for criminal liability, attorneys are appointed to represent them so that attorneys can guide them on whether or not they should be testifying. And what I can tell you is, in cases, if somebody is charged, hypothetically, if somebody is charged with a criminal case and they want to call, I don't know, their co-defendant, then that co-defendant has a right to have an attorney represent them so that they can help them navigate on whether or not they want to testify and what the potential legal and criminal consequences of that will be. So here's the thing. I'm just here to hear motions. All of this side thing that you're doing, we're not here to hear that.
It's not a side thing, Your Honor. It's crucial to my defense.
Mhm.
Okay.
All right, State.
Judge, I'm in receipt of the defendant's motion for continuance. We would object because, one, it is not timely. It is being filed on the day of trial, where the code necessitates that all pretrial motions be filed within 7 days of trial. And further, Judge, I don't believe this is notarized, so it wouldn't be in compliance with the Code of Criminal Procedure for a motion for continuance. Because of that, we respectfully ask the court deny the motion for continuance.
I disagree with this on the grounds of have no way to get, I don't have access to a notary. I presented it to the court the best way I knew how by giving it to the district clerk to present it to the court in this time. The reason for the 3-day continuance that I don't believe would be such a burden on the court proceedings is because I've been kept completely in the dark about all the evidence to do with this case. I don't have any idea of the way or the evidence or the witnesses that the district attorney is planning on using in this case. So therefore, I cannot build a reliable defense against something that I don't know that he has or not. He could just pop up with this mysterious evidence, and I have no clue of it. It's not a fair trial if I don't know what he's got to go against me with so that I can build my defense against it.
All right, this case has been pending for jury trial since October 9th, 2025. It is now February 3rd, 2026. And so we are proceeding with jury trial. So we're proceeding with jury trial.
I would like to object because I have no clue of the evidence that the district attorney has against me. Mr. McCray has not made me aware of any of the pretrial motions that were filed. And furthermore, he did not produce a single pretrial motion in this case. And he would not communicate with me regarding anything to do with this case. It's just, it is not any way can be considered fair that this ground we stand on for this contest if I don't know the facts of the case?
All right, motion for continuance is denied and the defendant will be fingerprinted. Is there anything else before the jury comes out?
Nothing from the state, Judge.
All right, thank you.
Judge, I'm sorry, I would ask for the timing for the defendant to be fingerprinted. Our fingerprint examiner is here. and
Let's
he's
do
ready
it
to
right
go.
now.
Thank you, Judge.
I
Thank you.
object to this, Your Honor. What is the reason for the district attorney's fingerprints? I have no clue of this. So I think in order for it to be fair, we have to be brought to speed about what it is that you need these fingerprints for when y'all got 10,000 copies of my fingerprints downstairs.
Okay, so this is what I will tell you. The state filed a motion. They're requesting your fingerprints.
For what reason,
The
Your Honor?
court has granted the motion. So he's going to take your fingerprints. So
Object.
please remove that objection.
Representing yourself may sound empowering, but in court, knowledge is survival. Missed deadlines, improper motions, and legal misunderstandings can destroy a defense before trial even begins.